Thanks for joining us again on Consumer Law Academy. I am Nick Wooten, and I am happy to be here with you. Thank you so much for taking time to watch the videos. What I'm trying to do with this process is give you more knowledge than I can give you when I'm teaching a CLE class, or in the aftermath of that when we're trying to stand around and talk sort of post-meeting and you have sort of specific questions. Well, Nick, how do you do this? How do you do that? How do you get these results? And I just don't have the time to give you the types of detail and analysis that I do in this format, where I can set aside time to talk about it from my own day and, donate my experience, my gains, what I've learned over the years to everyone else in this community who are doing their best to fight for normal people against moneyed and powered interest, and who have either less experience or less certainty of what they're doing, and who just want to know more and have a better sense of confidence that they're headed in the right direction. So with that said, we're talking now about the order of presentation of evidence and at trial. We've talked about marshaling evidence, trial planning, and essentially the order of presentation, you hope, is going to be able to follow your plan, which is to focus on the corporate defendant and run things in sequence from the corporate defendant's conduct all the way through to, its impact on your clients, and then your supporting evidence in the form of friends and family witnesses who can talk about how they've been, your clients have been impacted by this misconduct. So, order of presentation, the focus is always on the corporate defendant. We're always starting with the corporate defendant. We're always going from the corporate defendant or a corporate employee who is, one of those two scenarios where they're going to be the lead witness in the case, and then you're moving through to experts if necessary, and medical experts or medical treaters, not necessarily medical experts, and then your own clients and their story, then your friends and family witnesses, and in general, that should be your case in chief. And then if the defense, the corporate asshole, if they decide to call back a witness to try to rebut anything, then you deal with that. One thing I will tell you that personally I never do is I never even let them call their own experts first. I will not do that. I will control the trial. I will set the tempo of the trial. I will make sure that I present the evidence in the way that I want to, because I'm the plaintiff and I have the burden of proof. And so I'm going to attack the evidence that's there in the way that best suits me. And in consumer cases, that is almost always going to be with the corporate defendant. If you're doing personal injury, it'll always be with if you're at a car wreck, it'll be with the adverse driver or the adverse driver's employer if it's a commercial case, or the adverse corporate defendant if it's a corporate case, a commercial case. It's never really your client, because then the jury's looking for what your client did wrong and what they can criticize about your client's conduct, rather than, here's the wrongdoer, here's what they did wrong, here's how they did it wrong, here's why they did it wrong, here's why it's not going to get fixed, here's why they don't care, here's why you should pop them, those things. And so, we generally start with a corporate representative in a consumer case. That's generally the only witness for the defendant in a corporate case. Sometimes there are experts. Sometimes there are other company corporate defendant fact witnesses that are not the quote-unquote corporate representative. And you have to balance those scenarios out and game them out based on what's going to work best for your case. In the Garcia case, the case we tried against Wells Fargo for 3 days this past summer, June of 2023. Before we resolved the case, during a break, we started that trial with the defendant's expert on banking practices, mortgage servicing practices. We called their expert as the first witness, which is, if you talk to people who try a lot of cases, they will tell you that is an unusual move. But I was confident that I knew the mortgage servicing industry better than he did, and that I had lived through the financial crisis and the changes in the mortgage servicing industry, and I knew those as well as anyone. And so I felt like I could use that witness to set the background, explain the problem, and sort of set the stage for how my clients lost their house. And then from there, once I'd gotten through all the sort of factual background that we could agree on, then I could drill down and really dig into the guy and beat up on him pretty bad. And that was interesting because we started testimony on a Friday, went for a couple hours, moved back on Monday. We were, testimony kicked back up. We interrupted testimony to have a doctor come in and testify who had been hired by them, but then they had abandoned him because he had not been as critical of my clients as they wanted him to be. So then I called him back as a fact witness and sort of showed that they, didn't like his opinion so much because he found that my client actually had real problems and wasn't a faker, which is what they wanted him to say. And then they had their crack at trying to explain what they did. And then their financial expert came back on and beat up on him a little more. They took him on their cross, which was their direct. And then, the next day we were due to get back into him. And then, the case resolved. But very unusual in the sense that we never got the Wells Fargo person on the stand. We were, dealing with their experts. Most of the time, in other cases, first person goes on the stand is the corporate representative who's there to speak for the company. And so there was a unique difference there. Very rarely do you find a scenario where it benefits you to have your client on the stand first. Keep that in mind. And so, once we've dealt with the corporate people, however many there are, we've dealt with experts, however many there are, we deal with treating physicians, however many are going to testify, usually no more than one, maybe two, just depending on exactly what's going on, or if there's like a married couple who are having these issues and one has one doctor, one has another. But, a couple of medical people. Sometimes we put those people on by deposition, transcript, excerpt, where we're just videotape the deposition and just put in, questions from there. And then after that, the next thing that we work on is usually our client. And we, at that point, we want our client to talk about, confirm what happened to them, basically. Talk about how it impacted their life, sort of what it put them through, which is always, as you know, if you're in this business, very traumatic and life-changing for most people. If it's been a big event like the loss of the family home or the invasion of the family home or something of that nature, or if it's a car crash case, someone's been maimed or killed. So, our clients always get on. We always try to present our clients in such a way that they're, I don't ever want them to appear like they're just up there whining or begging somebody to side with them and agree with them on a verdict. I want them to get up and tell their story and talk about how things have impacted them, and also be able to talk about what they've done to try to overcome. And it doesn't mean that they're not hurt because they tried to overcome. It just means that, they had some degree of success or not trying to get over whatever it was that's happened to them. And then, what I call the quote unquote anchor man of these trials is always the friends and family witnesses. And those are the people who, know our people best and who know what they've been through and have a very unique perspective on how these horrible events have impacted our clients in a way that's usually the most powerful part of the evidence in the case as far as proving the harm to your clients. When I tried the Sacramento case in Chicago, we had her 2 adult children testify, and Manette asked to be excused because she didn't want to hear her children talk about how her experience with Ocwen had impacted her life. And so Judge Gottschall graciously allowed her to not be in the courtroom during that testimony. But our children talked about things like her daughter talked about her mother not being present, being distracted, her mind being somewhere else, her focus and her energy being on this problem with Ocwen and this fear of losing her home, rather than her engagement, her wedding, her birth of her first child, those things. Our son testified that he thought she was taking drugs or something because they were losing the family home and didn't understand why she was having her home taken and things like that. And lost a job because she couldn't quit obsessing over Ocwen's accounting practices that had her loan showing up as being in default when it wasn't supposed to be in default, when she'd paid every dollar she was supposed to pay. And we had a coworker come in and talk about how she had obsessed to the point that she'd stopped working, and she started bothering coworkers, asking them to check her calculations, and being tearful and upset, things of that nature that were in detail and very powerful. We had in the Hammer case, we had a next door neighbor who said that Miss Hammer's house had been a source of light and joy and activity and family, and then when her bank started trying to take her home and not give her the modification that they had agreed to, that her house became shut off and dark and isolated, and Miss Hammer had kind of quit living. She more or less guarding her home. And son talked about his mom's light being put out, which was an incredibly powerful moment. And those are things that defense lawyers in general have a hard time dealing with, because my colleagues in the defense bar are sort of rote and analytical, and often very good writers and speakers, but they often, I think, mentally and emotionally shield themselves from the reality of the harm that their clients inflict on people. And to do that, you have to shut off, to a certain degree, your ability to actually process the power of that type of testimony. And then, of course, the lawyer's question of the day: what do you even do with it? If you're on the other side, if you start asking typical defense lawyer questions, well, you love the plaintiff, they're your family member, you would say anything to help them, blah blah blah. You just look like an asshole. Sorry, it's just nothing you can do. You just look like a douchebag, and the jury's going to get pissed at you, and they're going to lop your client's head off. Just the way it goes. The best thing they could ever do is just shut their mouth and say, thank you for your testimony, or no questions, and let those people get out the door, which they hate because it leaves that powerful testimony lingering in the air like a cloud. And I'm sure if you're on the other side of that, it probably feels a lot like swallowing a bag of turds, because you're just like, I feel like I need to do something about this, but I don't know what to do. And the answer is, there's nothing they can really do, because the injuries are real and the impact is real. And these people have observed it and seen it and can quantify it in a way that brings it home to normal jurors. And really, it's a gut punch. And, I often have difficult times with this testimony, because by the time I get to a trial, it's so lived for me. It's so real. And I've seen how much my client's been impacted. So I have a difficult time getting through some of this testimony. And if I were a juror sitting there listening to this, I mean, I would just be mortified at what had happened to these people. And I think that's what happens. And I typically, you know, if my client, I think, is going to have trouble or not be very articulate or not be willing to fully delve into the emotions of what they've lived through because of the trauma or whatever, you know, I always like to have at least one of those friends and family witnesses at the end, sometimes all of them, after my clients, you know, and that's where I want to rest with those things that are super powerful, those things that, you know, sort of end the story with, this is what the consumer has left thanks to this giant corporate asshole. And when you have that environment, you have left that huge negative thick in the courtroom, and you can feel it. And defendants hate that and don't know what to do with it, and that's just an incredibly strong way for you to end the trial, for you to rest. And so, you know, when you're thinking about your order of presentation, that should be where you go. You should know that the idea is to start with the wrongdoing and end with the destruction. That's your set, right? And everything else fits between there. Start with the wrongdoing, end with the destruction. And that's the right way to try your portion of the case. And then, of course, like we said, be prepared for whatever the defendants may throw up at you, but deny them the ability to lead their witnesses, deny them the ability to lead their experts, deny them the ability to tell a coherent story. Use their witnesses to prove the wrongdoing, destroy the ability to tell whatever made up lie they've come up with before they get a chance to do it. And in your best cases, if you've done all that well, they won't have any witnesses to call, and anyone that they try to call to do anything other than to apologize for what's happened to the plaintiff, they will look like fakes and assholes who don't care that they destroyed someone's life. And that's a pretty good place to be if you want to be successful at a high level. Because when they're fake assholes that don't care, what that tells a jury is you really have to step on these people to get their attention. And that's exactly where you want to be if you want to get the best possible outcome, which is the goal. The goal of a trial is not to go try the case for the hell of doing it. The goal of the trial is to make sure that it's much more expensive to walk in a courtroom with you than it is to settle the case for whatever you've demanded, and to repeatedly teach that lesson until people understand it. And so if you don't understand how to get that done, can't make it expensive for the people who want to do it. So start with the wrongdoing, end with the destruction, dare them to get up and act like an asshole after that. That's your order of presentation. I hope you appreciate the video. I hope you enjoyed it. I hope it helps with your planning and thought processes as you're getting ready for trial. And again, thank you for joining us with the Consumer Trial Lawyer Academy. Like and subscribe, Facebook, or not Facebook, YouTube. They say that's super important. And again, appreciate your time. Look forward to sharing with you more in the future. And tell your friends, tell your law school students, tell everyone you know they think this might be interesting. Looking forward to serving a lot of people, sharing what we know. Thank you, and talk soon.